Welcome to the next edition of War Story Wednesdays. Today I want to talk about a case that I term Liar, Liar, Pants on Fire. Turns out that Bill has been looking to buy some real estate to develop down in Los Angeles. And he's been working with his broker Leroy for months to try to find just the right piece, a big enough piece in the right location, all that good stuff. And Leroy is just struggling with coming up with a piece that will work for Bill. And he's bemoaning about this difficult project to one of his buddies, Marshall, down at the country club. And Marshall says, "But Leroy, I know just the piece for you." "Really?" "Yeah, it's this 70 acres down here that Sunset Oil is selling. You ought to go take a look." And sure enough, Leroy gets in the car and goes down there, and it might be just exactly what Bill's looking for. So, one thing though is he notices a sign that's got a different real estate broker on it. For sale by Jim Jones. So, Leroy calls up Marshall and says, "We like it. Bill wants to make an offer, but what's the deal with Jim Jones?" So, "Oh, don't worry about that. That's an old listing. I've got it listed with Sunset Oil. You can bring it through me. We got you covered." So Leroy and Bill work it out. They come up with an offer price, $4,000 an acre. They submit it, and Marshall takes it to Sunset Oil and comes back with a counteroffer. Sunset wants $5,000 an acre, and they want you to increase the amount of the down payment, 50%, all cash. So Bill and Leroy talk about it, and okay, we'll do it. They amend the offer, they submit it, and Sunset accepts it. It's all good. Comes time for the closing papers. And Bill and Leroy are at the title company signing off stuff, and it's not Sunset Oil that's the seller. It's Marshall's partner, Jordan, who's the seller. And so they ask, what's that all about? "Oh, it's part of the fixing up of the listing agreement stuff with the other broker, and we're taking care of some tax problems, and it's all just pro forma, don't worry about it." So they sign off and off they go, and Bill gets the property and he's really happy. He starts doing some entitlement processing to get it ready for development, and he finds out that Sunset Oil really was the seller, not this Jordan person. And he finds out that Marshall bought the property for $4,000 an acre and resold it to Bill at $5,000 an acre. And that Marshall made up all of this business about the exclusive listing belonged to him, and that there was a tax problem, which is why the closing papers needed to be done differently. And really, Marshall used Bill's 50% down payment as Marshall's down payment to buy the property from Sunset Oil. He just outright snookered him, bought it from Sunset and resold it to Bill. Well, that made Bill a little unhappy. I guess it would make anybody a little unhappy, so he sued Marshall to get his money back, his extra $1,000 an acre. And he won, and the court awarded punitive damages against Marshall as well. And Marshall appealed. He thought that that was unfair, because after all, the property was worth $5,000 an acre. And the way the law was at the time, if you're going to sue for fraud, well, you only get the difference in the value of the real estate. And there was no difference, because it was worth what Bill paid at $5,000 an acre. And the court said, yeah, no, we're not going to let you get away with that. It was unjust enrichment that Marshall was able to get by selling the property without disclosing that he was flipping it to Bill. And so the court imposed what's called a constructive trust over the real estate and made Marshall give Bill the extra $1,000 an acre. And then Marshall said, "But the award in the trial court was that I had to pay all of the commissions and everything, and well, Bill would have had to have paid a commission no matter what, so I, Marshall, shouldn't have to pay those commissions. Bill should." And the court said, "No, we're not going to let that happen. Because part of the penalty that we're going to impose upon you is all of the costs, including the commissions that would have otherwise been paid anyway, because," and this is the part where, adding insult to injury comes in, the court said to Marshall, Bill might not have had to have paid all of those commissions, or at least that much, and it would be too speculative to try to consider how much Bill would have paid if the deal had been legitimate. So we're just going to let you pay them. That's an ouch, because we all know the commissions are payable on a deal. And it proves the point that no bad deed will go unpunished. Sometimes no good deed goes unpunished. But in this case, Marshall got everything he deserved, and the court needed to work it around a little bit to come up with the appropriate theory, because Marshall was not a fiduciary to Bill. He wasn't an agent. So a regular, typical breach of fiduciary duty claim wouldn't have worked. There are other circumstances where a real estate broker can and has gotten into trouble by doing the same thing to a client, where the real estate broker offers up a piece of property to a customer, the customer says no, or the customer makes a low bid and the real estate broker knows that the property is worth more and makes a higher bid and cuts the client out of the deal. Or where a real estate broker knows that he's got a client under a buyer's representation agreement, and the buyer is relying on the real estate broker to find certain type of property for the client. And the broker goes ahead and buys something so that the broker can make a profit and resell it to that client. Once you've established the agency relationship, you have a fiduciary duty to put the client's interests ahead of yours. It's okay to flip property and to make a profit. It's not okay to do it secretly, and it's not okay to cheat a client out of the profit that the client would have made had you brought that property to the client.